Right now, thousands of people are setting up LLCs because everyone tells them it's the ultimate way to protect their assets. And if you did that, congratulations, you did the smart thing. You set up the entity, you got the paperwork, and you figure your house, your savings, your retirement, they're all completely off the table in the event of a lawsuit. And guess what? Most of the time, you're right. That is exactly what an LLC is supposed to do. But that is the exact reason this belief is so incredibly dangerous, because it's mostly right. You stop thinking about it. And that is the exact moment your protection begins to silently erode on you. So here's a brutal truth, that millions of entrepreneurs are walking around with a completely false sense of security, that their LLCs are just paper tigers waiting to collapse. Not because the entity itself failed, but because of how they were actually running it day to day. You see, the second a real lawsuit hits, a good attorney is going to care about that piece of paper that you use to create your entity. They're going to go and look right past your company and come straight for your personal bank accounts and everything you've built outside of the business. You see, you don't have to commit fraud to lose your LLC shield. You just have to make a few quiet, everyday mistakes, and then boom, they come right to you. You see, there are 6 hidden traps that mean your LLC is set up to fail right now. And in this video, what I'm going to do is I'm going to walk you through them and exactly what you should be doing to bulletproof your assets before it's too late. Okay, so what I want to begin with is one of these seminal cases out of 2002 that is everyone refers to as a landmark case. And this was Casey Land v. and Livestock via Flave. And in that situation, which really sets the framework for this video, you see a company caused damages to someone's property. When the victim sued, the company had no money. So they asked the court a simple question: can we go through the company and hold the owner personally liable? And the court said something that should stop every LLC owner cold. It said, hey, there's no reason in either law or policy to treat LLCs different than corporations. In plain English, yes, a court can pierce the veil of your limited liability company. And that's the term for when a court ignores your company and lets a creditor reach your personal assets. I mean, this is why we're setting up LLCs, correct? Is to ensure that if something happens inside of the business, stays in the business. But there are situations where what's happened inside creeps to the outside and puts all your personal assets at risk. You see, here's the part that matters most. In that case, there was no fraud involved. Nobody had to prove that the owner was a crook. You didn't have to be a criminal to lose your protection. You just have to give the court enough reasons to decide that your LLC was never really separate from you. And so today I'm going to show you the 6 most common ways business owners do exactly that, usually without realizing it. And this isn't some, Wyoming quirk. Courts across the country have landed in the same place. An LLC that isn't run as a genuinely separate business doesn't get treated as one. The state on the paperwork changes, right? The rule doesn't. Okay, so way number 1, okay, the first way in which people get to you is called a lapsed entity. So consider Susan. Susan sets up her LLC years ago. She did everything right at the very beginning, but 2 years back, she forgot to file her annual report with the state. Then she forgot again. And without any warning, okay, she noticed the state administratively dissolved her limited liability company. And that's where the state formally shuts her company down for not keeping up with her filings. And she had no idea. She kept signing contracts, kept running her business under the company name. On paper, the business no longer existed. Then she was involved in a lawsuit. There was a contract claim there. And the first thing the other side's attorney did was pull her record from the Secretary of State, where it showed in black and white that her limited liability company was dissolved. Okay, so here's a rule. A dissolved LLC is not a shield, okay? And this one isn't even technically piercing the veil, because there's no veil left to pierce, because there's no company. It's one of the things I tell people when they first come to us and they say they have existing business entities. I say, hey, first we need to search and see where your business entities stand. And I can confidently say at about 18 to 24% of the time, the people that we're working with, they have an entity that they think is legal, protecting them, avails intact, when in actuality, the company has been dissolved by the Secretary of State because they forgot to renew it. All right? And so what that means is that if somebody were to sue that entity, they look right to the entity and they go after the owner, all right, for everything they own. Now, there's a way to keep every entity in good standing across every state you touch, and that's to structure things so that one misfiling doesn't take down your whole system. Okay, and what I tell people is use a compliance calendar, okay, or use something else, which I think is better, is have someone actively monitoring your system for you. So you don't have to worry about it. Focus on your business, but use a monitoring service to make sure that your entities always stay in compliance. All right, the way number 2, okay, you never act through the entity, and this is a mistake as well. So let's assume that we'll pick someone else, Lisa. So say Lisa, she's got this brand new LLC, formed properly, it's in good standing, but watch how she does business, right? And this is pretty common. She signs her contracts in her name, Lisa Greer, just her name, no LLC. Her invoices say her name, her proposals, her emails, all personal. And this happens a lot with business owners. Even their business card many times will have their name on it and not their LLC name. Or they'll put the name of the company and they'll forget to put on LLC after the name. I catch this all the time at my events where people will come up to me and hand me their business cards during a break at the event, and I'll look at the card and I'll see that just their name. I'll say, do you have a business? Yeah, I have a business. Well, why isn't it on your card? Why isn't it adequately spelled out there so I know I'm dealing with a company? See, this is a real problem. And the attorney, if they're suing your company, it's a real simple argument they make is that, hey, my client didn't do business with an LLC. They did business with Lisa. So you should probably figure out what the rule is, right? The protection only works if you consistently hold the company out as the one doing the deal. That means signing in your representative capacity, which means signing as the company, not as yourself. So that means you also have to understand what your position is within the company. So when you set up an LLC, you have 2 different ways you can set up an LLC. It can be member managed, okay, or manager managed. And I'm surprised how many people don't even know what type of LLC they have when I ask them. They say, well, it's an LLC. I said, well, what type? And they don't understand. There's 2 different types, member manager, manager managed. And so that's important because if you set up a manager managed LLC, then whenever you sign it, she would sign Lisa Greer, manager, on all of her documents. That's how she was signed because it's manager managed. And I assume she's the manager of the company. Where if it was member managed, then she would sign member manager. Just like that. So now she's signing appropriately for the company and designating the company. So typically the company name would be right up here. The design LLC would be right here. I'm just going to put DLLC, and then she would sign down below, right? That's how you protect yourself and keep your veil there. Now, sometimes people think, well, it's a single member LLC. Is it really that important? Oh, absolutely. It's even more important with the single member LLC because there's no partner involved, no other people. It's just you. So every contract, every lease, every business card is either a chance to show that you're acting as the company or a chance to show you that you weren't. Now, the fix, it's really simple. It's a signing protocol and a document standard you follow every single time. Okay, most owners just have never been shown what it looks like. Okay, and then when we're working with our clients, we set their entities up. We show them exactly how they need to sign every single time so they don't make these mistakes. Okay, now the next one. I'm going to refer to this. Number 3 is going to be commingling. Of course, that's the big one. So using examples again, let's say we had some individual named Ryan, and Ryan treats his business like a bank account, his own wallet. So when he goes to the grocery store and he has his credit cards, he pulls out and he puts it on his business name. Maybe even pays his mortgage out of the LLC. I've seen that happen before. Tuition, vacation, okay, all flowing out of the LLC, and he really doesn't have a separate personal account anymore. the business has become his account. And this really happens a lot. I found when I'm working with people who are, again, using an LLC where it's a single member. And so what you're doing there is you're commingling assets. You're just mixing personal and business money together. And it's the single clearest signal to a court that, hey, okay, this person has failed the basic test of keeping their business assets separate from their personal assets. It's what it's what courts usually call a unity of interest. That's the idea that you and your LLC have become so intertwined that there's really no separation left. So when your money and the company's money are the same money, the company stops looking like a separate person. And of course, the court's going to treat it that way, because if you fail to treat it that way, then they will. So what's the fix? Okay, it's a clean structure for how the money moves. So when you're looking to fix something like that, this is what I tell people. Let's assume that you have your limited liability company right here, and you're the member of your LLC, and it has money inside of it. Okay, so when you need money from your LLC because you have a bill to pay, maybe it's tuition, what you do is you take a distribution. Okay, this is key. You take a distribution out of your limited liability company. That means it goes from your LLC to you personally. Okay, not like this. I've seen people do this before. They'll have a second LLC over here that holds all their savings, right? So this is their business, and this is the LLC they set up that owns their savings. They'll move money this way as well. You don't want to do that. Okay, you only move money wherever you see a line tying things together. And as you see here, this person right here is tied to this LLC as its member. So you take the money out as a distribution, and then you take that distribution, either you move it up to here or you pay for the expenses that are personal in nature with that money you pulled out of the limited liability company. That's really important when you're running this. Now, since I'm on this structure right here, let's talk about number 4, which would be undocumented draws and loans. Okay, those are other ways in which you can pull money out of your company, and sometimes they refer to this as the quiet cousin of commingling. So when you're running your business, right, if you're going to take money out of here, then you want to make sure you're documenting it properly. And so what I did here is I called this a distribution. So you keep track of all of this. Every time you pull money out, you want to make sure there's a paper trail, some way so that if a court looked at it, they know exactly why those funds were coming out of that business. So what you would do when your bank account, like for example, in my situation, whenever I take out a distribution of the profits to myself or just of the principal that's in there, I list on the transfer, because I transfer it online, I list it as a distribution. Now, if you wanted to loan yourself money, if you want to get a real loan from your own company, which there's reasons to do that as well where you don't want a distribution, then if I was going to take out a loan, so say I'm going to do a loan to myself, then what you need to have is what we call a promissory note. So you need to have a promissory note between your LLC and you personally. Again, and that promissory note states when you're going to pay it back, how you're going to pay it back, what the interest rate is, all the things you would have to go through if you were borrowing money from a bank. Okay, so the fix here is really simple. Just document things, right? Keep track of it. So like I was drawing out for you, as long as you're documenting how you're pulling money out of your business or when you're putting money in, it removes the argument that someone's going to make that is the opposite side, opposing counsel. You take that argument off the table, right? Because you can back it up. And I'll just pause here and let you know about this. So we recently had a client a couple of months ago. Their LLC they were being sued personally, and they were trying to reverse veil pierce, break their LLCs to get after the assets inside of the limited liability company. Because we did such a great job at protecting their assets, they realized that's where the recovery was. And they had the clients come in, and they spent several days in court going through their operating agreements. I have another video on the importance of putting together operating agreements and how operating agreements can be your Achilles heel as well. But check that out. I'll put a link to it in the show notes for you, so you can click on that, go down and search for that video. It's an important video to watch. But the fact of the matter is, not only look at the operating agreement, they wanted to see how the transactions, the money flowed. And they are focused in on that, because if they could start showing the things that I'm talking about, then there was a way for them to get through the LLC. All right, way number 5. the undercapitalized shell. So this takes us back to the very beginning. Remember that example I gave you about that company, okay, when they came after the LLC and it was empty. Okay, the emptiness wasn't an accident. If actually it became the problem. You see, if you set up a limited liability company, and let me just go back to my screen here again. Let's say you set up an LLC here, okay, and this LLC was set up for a business. And you open up a bank account, you put $1 inside of it because you figure, hey, I don't know how this business is going to run. I don't want to put a lot of capital at risk. And then you go out and start entering into contracts with third parties to get them to provide services to your business. But then on this side, you're not selling very well. So you're not bringing in enough money to pay these people off. So then you default on all of that. Well, here's what can happen. A court could look at this and said, when you only put $1 into your business, you undercapitalized it. You didn't have enough operating cash in there to satisfy, reasonable expenses. And you can make this worse if you don't have insurance as well. So by not having insurance, you just compound the problem. So what they say here is when this LLC is nothing but an empty shell holding risk, that is the risk of these people suing, and there's nothing there for them to recover, no insurance, and there's hardly zero assets, then the court can decide, hey, this was never a real business. It's just a liability sponge that you're hiding behind, okay? And so there they can use that to pierce the veil of the company and go after you, and they'll reach after your assets. So make sure you're adequately capitalizing the company, and of course, if you're the type of business you're engaged in, you have insurance. So that is, the fix is always having a good balance of that. And so sometimes people say, well, what happens if I have real estate inside of the LLC? Does that mean I need to keep a lot of cash in there? No, it doesn't. Insurance, but remember, the real estate's also an asset. So you do have assets, and you can argue we're not undercapitalized. So you don't need to keep a lot of cash if it's a situation with real property. Okay, the sixth way in which they do this is there's no arm's length between your entities. And this is the one that catches people who think they've already solved everything else I was talking about. It's the people that have more than one limited liability company. And I see it quite a lot, and I already hinted at this earlier, where people will create LLCs. I see this mainly in the real estate context. Let's say somebody has 3 limited liability companies here, and all of them own rental properties. Actually, let's say on top of that, they have their own business up here. This is their business. Maybe it's an S corp. So what ends up happening, because they have a structure that looks something like this, where all these businesses are owned by their Wyoming LLC, okay, when they need money, okay, from, say, this property right here, we need to do, there's a turn going on, and we do a lot of rehab work to get it rent ready again. Maybe it was already coming up that we had to replace a lot of stuff. We're just waiting for the tenant to move out. And it's going to run us to do this turn because of all the work, new roof, things of that nature. It's going to run us $24,000. And this LLC only has $1,500 in its bank account. So what will end up happening, unfortunately, sometimes is people maybe take their active business and have their business pay for the contractor to come out and re-roof the house. Maybe they'll take this LLC over here and pay for the painting contractor to come out because you got cash sitting in this account right here, or you have cash sitting in this account over here. So you pay it right over. You pay the tradesman that's providing the service to the property and for the supplies and materials. See, that's a huge problem right here because you can do this, but in order to do it this way, you have to document it. So you have to show your loan and money. These would all have to be structured as loans. You just can't pay the money over there on the behalf. Otherwise, the courts will look at this as just this one big hairy enterprise, and they're going to collapse it all down into one. And because you're failing to ignore the separateness of the business. So if you ignore it, then the court will ignore it. So the very thing you built to contain your risk now becomes one giant target. And if a lawsuit starts over here, actually, let's just say it starts right here, because one of those contractors over here is injured in this LLC while they're doing the work. They fell off the roof. Guess what? They sue this company, they sue this company, they sue this company, and they sue this company. All of those now are at risk because of that injury. So this is what you need to do, is make sure, as I stated earlier, that you keep things separate and you're deliberate about how you move money around. So how would you solve this problem, you might be wondering? You take a distribution out of this company to yourself for that contractor. You then take the money and move it into here, and then from there you move it into this LLC. Now, if I had money here that I wanted over here, I would take a distribution to here and then I'd move it up. Distribution to here and then I move it up. And then just have this entity right here, which is pretty friggin' messy now what I have here, paying for all the expenses. And you keep all this other stuff out of the picture. So if anybody gets injured, then all they see and all they can point at is this company right here as the one that is containing the risk. So that's how you go about setting this up. This is the framework and things you need to look out for, because when the lawsuit hits one of these entities, I guarantee you creditors are going to look for a way to start pulling on a thread that could start creating major problems to unravel that company and the protection that has been providing you. So setting up an LLC is step one, okay? You've already done that. Maybe you haven't. Step two is making sure that it actually holds when someone tests this. I tell people this all the time. Until your LLC has been tested, and I mean, we don't want them to, you don't know what you have, okay? So if you got one LLC, if you got more than one LLC, and you're not 100% sure that your structure is going to survive a real lawsuit, well, that's what I suggest you do. Hey, reach out to our team. Get a free strategy session. We'll help walk you through to figure that out, to let you know where the weak spots might be in your existing plan, where the gaps are, and what you can do to fix those gaps now. All you got to do, go into the show notes. I have a link there for a free strategy session, and it could be the difference, if you're involved in a lawsuit, between having an LLC and being protected by one. Guys, hope you liked the video. Be sure to hit the like button on this, and if you're not yet a subscriber, subscribe to the channel. Take care.